On May 12, 2023, Iowa's Governor Kim Reynolds signed legislation that will limit payouts in lawsuits following a CMV accident, which are referred to as nuclear verdicts. ATRI defined nuclear verdicts as a case where more than $10 million is paid out to a victim of a trucking accident. When a truck driver is found to be at fault, truckers or a trucking company's insurance has to cover that, which you can assume can be crippling to a trucking company. Representative Bill Gustoff said, "Iowa ranks as one of the top states to do business, and we are just trying to keep it that way by avoiding some of these nuclear verdicts that we've seen in a lot of other states." So you're probably thinking, this is good news, right? Well, of course it is. It's always a good thing when your bill is cut in half, especially when the accident isn't even the driver's fault. Well, this new law is capping non-economic damages at $5 million per plaintiff for pain and suffering. This applies to lawsuits brought against trucking companies where the CMV driver is found to be the cause of the accident. Now remember, this is only in Iowa, but hopefully other states will follow suit. If you have questions at this point, just fill out the form below, and a DOT compliance specialist will get back to you within 24 hours. There are some exceptions, and this cap can be waived under special circumstances, which includes accidents where the driver is under the influence of drugs and alcohol, refuses to submit to chemical testing, was also committing a felony, was involved in the manufacturing or distributing of controlled substances, did not have a proper commercial driver's license, was driving a vehicle involved in human trafficking, was driving recklessly, was using a mobile phone, computer, tablet, or other device while driving, or was speeding, going 15 miles an hour over the posted speed limit. In addition, a trucking company cannot be sued for negligence in hiring a truck driver who is involved in a crash, but the carrier can be sued for direct negligence in supervising, training, or trusting an employee. Now, why is this tort reform so important? Well, first of all, this is the third state that has recently passed or discussed passing some type of tort reform. Only 47 more to go. Either way, this is helping bring some stability to the insurance market for trucking companies, with the idea being that imposing these limits will bring down the insurance rates, since the total cost of claims and litigation can ultimately be reduced over time. As a carrier, you should strive to stay DOT compliant in an effort to protect drivers and your company. Litigators will look for unsafe driver patterns by inspecting the crash information and driver documents like driver qualification files, training records, pre- and post-trip inspection reports, daily activity logs, and post-collision alcohol and drug testing results. If all these documents are managed well, whether it be by the company itself or an external compliance company like CNS, unsafe driver trends, violations, and fines are much less likely. If you have questions about driver hiring, training, and driver qualification file management, or just staying compliant in general, you can fill out the form below or give CNS a call at 888-260-9448, and one of our DOT compliance specialists will help you